Article 11, justifying circumstances, the following do not incur. Number 1. Anyone who acts in defense of his person or rights provided that the following circumstances concur. First, unlawful aggression. Second, reasonable necessity of the means employed to prevent or refill it. Third, lack of sufficient provocation of the part of the person defending himself. Number 2, anyone who acts in defense of the person or rights of his spouse, descendants, or legitimate, natural, or adopted brother of his, or sisters, or his relatives by affinity on the same decrees. Consequently, within the fourth civil decree, provided that the first and second requisites prescribed in the next proceeding circumstances are present, and the further requisites in case the revocation was given by the person. Attack that the one making defense had no party therein. Number 3, anyone who acts in defense of the person or rights of a stranger provided that the first and the second requisites mentioned in the first circumstances of his article are present, and that the person defending but not induced by revenge, resentment, or other evil motive. Number 4, any person who, in order to avoid an evil or injury, does not act which causes damage to another, provided that the following requisites are present. First, that the evil sought to be avoided actually exists. Second, that the injury feared by greater than to avoid it. Third, that there be no other practical and less harmful means of preventing any person who acts in the fulfillment of a duty or in the lawful exercise of a right or office. Number 6, any person who acts in obedience to an order issued by the supervisor for the same lawful purpose. Article 12. And number 1, an imbecile or an insane person, unless the latter has acted during a lucid interval. Number 2, a person under 9 years old. Number 3, a person over 9 years old and under 15, unless he has acted with discernment, in which case, such as minor shall be proceeded against in accordance with the provision of Article 80 of this code. When such minor is adjudged to be criminally irresponsible, then the court, in conformably with the provisions of this and the preceding paragraph, shall commit him to the care and custody of his family, who shall be charged with the surveillance and education. Otherwise, he shall be committed to the care of some institution or person mentioned is said Article 80.
13. I-relax nyo eh.
Ayun na, dito na.
Ah, dito na. Lord! Sugaw eh. Isa, 1, 2, 3.
Article 13. Mitigating circumstances. The following are mitigating circumstances. Those are mentioned in the preceding chapter, where all the requisites necessary to justify or to exempt from criminal liability in the respective causes are not attendant. Number 2, that the offender is under 18 years of age or over 70 years. In the case of minor, he shall be proceeded against in the accordance with the provisions of Article 80. Number 3, no intention to commit so grave a wrong as that committed. Number 4, the sufficient provocation or into the part of the offended party immediately preceded the act. Number 7, that the act was committed in the immediate vindication of a grave offense to the one committing the felony, delito, his spouse, ascendants, or relatives by affinity within the same decrees. Number 6, that of having acted upon the impulse so powerful or as natural to have produced passion or obfuscation. Number 7, that the offender had voluntarily surrendered himself to a person in authority or his agent or the court prior to the presentations of the evidence. For the prosecution. Number 8, that the offender is deaf and dumb, blind, or otherwise suffering some physical defect, which this restricts his means of action, defense, or communication with his fellow beings. Number 9, such illness of the offender as well diminish the exercise of the willpower of the offender without conscious of his act. Number 10, and finally, any other circumstances of similar analogous to those above mentioned. Article 14, aggravating circumstances. The following. Number 1, that the advantage be taken the offender of his public position. Number 2, that the crime be committed in contempt or with insult to the public authorities. Number 3, that the act committed with insult or in disregard of the respect due to the offender account of his rank, age, or sex that is be committed in the dwelling of the offended party. If that latter has not given provocation. Number 4, that the act be committed with abuse of confidence or abuse ungratefulness. Number 5, that the crime be committed in the place of this chief execution or in his presence. Number 6, that the crime be committed in the night time shall be deemed to have been committed by a band. Number 7, that the crime be committed on the occasion, conflagration, shipwreck. Number 8, that the crime be committed with the aid of armed men or pressure. Number 9, that the accused is recidivist. Number 10, that the offender has been previously punished by offense to which the law attached. Number 11, that the crime be committed in consideration of a price, reward, or promise. Number 12, that the crime be committed in consideration of a price, indication, fire, poison, explosion, stranding, or vice, of vessel. Number 13, that the act be committed with any other evidence, premeditation. Number 14, that the craft, fraud, or disguise be employed. Number 15, that the advantage be taken of superior strength to weaken the defense. Number 16, that the act be committed with treachery or elevation. Number 17, that the means be employed or circumstance brought about with ad economy. Number 18, that the crime be committed after an lawful entry. Number 20, that the crime be committed person under 15 years of age by means of violence, means arson, or other similar means as are amended by RE 5438. Number 21, that the wrong done in the commission of the crime be deliberately argumented by causing of the wrong not necessary for its commissions. Article 15. Their concept, alternative circumstances are those which must be taken into consideration of aggravating, mitigating according to the nature and effects of the crime and the other conditions attending its commission. They are the relationship, intoxication of the offender. The intoxication of the offender shall be taken into the consideration as a mitigating circumstances when the offender has committed a felony in a state of intoxication of the same is not habitual or subsequent to the plan commit said felony, but when the intoxication is habitual or intentional, it shall be considered as an aggravating circumstances.